Hello, this is John P.L.L.C, and this begins a live webinar on trustees behaving badly. What you need to know. Hello, my name is John P.L.L.C. I'm a probate and trust litigation attorney with P.L.L.C. Hauser in downtown West Palm Beach, Florida. We're located at 415 South Olive Avenue, a few blocks from the main state courthouse and not far from the federal courthouses, just one block west of Florida's Intracoastal. And for the next 30 to 50 minutes, we're going to be offering a free webinar on the role of a trustee of a family trust, and more specifically, how some trustees of a revocable or irrevocable trust sometimes get into trouble. The title of the seminar is Trustees Behaving Badly, What You Need to Know. And we're going to be analyzing in very basic terms some of the obligations and duties of a trustee, where trustees often make some mistakes. And if you're a beneficiary, things you might want to know about your trustee and things that certain rights that you have and things that you can later learn about. So if you're a trust beneficiary, maybe mom or dad created a trust and they're still living, but you're going to be a beneficiary in the future, you might want to listen to this. Or maybe you're the beneficiary of a revocable or living trust that is now irrevocable, and you have rights that you may not know about. Or maybe you just question some of the things that your trustee is doing. Stay with us for the next 30 minutes. You're going to learn a lot. Or maybe you're a trustee. You're administering a revocable trust for a spouse or a loved one or a family friend, and maybe you're administering it for children or stepchildren or beneficiaries that you're not related to by blood or marriage, and you want to know what your obligations are as a trustee. Stay with us for the next 30 minutes. So I'm going to go into the discussion topics in just a moment, but let me start by saying that today's webinar is free of charge and sponsored by P.L.L.C. Hauser. Our practice is limited to estate and trust litigation, probate, guardianship litigation. We handle very limited estate and trust administration, but we often do help executors or personal representatives and trustees with those matters. And my law partner, Rob Hauser, is board certified in appellate law. He handles all the appeals for the court, for the firm, and he has a very vigorous appellate practice. So if we can ever assist you with appeals, we'd love to hear from you. Today's webinar is not the only webinar that we're offering. We have a host of webinars on various probate, estate, and trust topics throughout Florida, and we invite you to visit our website, phflorida.com, where you can see and listen to and observe webinars free of charge. So today is a layperson's webinar. This is intended for a non-lawyer, although we have a number of webinars for Florida attorneys that qualify for continuing legal education credit or CLE credit. So if you're a Florida attorney and you practice in the area of wills, trusts, and estates, feel free to visit our website and you'll be able to see what webinars we have free of charge, where you can actually get credits from the Florida Bar and ethics credits. For example, in December of 2016, we had 3.5 hours of ethics credits. In 2017 so far, we've had seminars on various topics in the probate world, as well as charging liens, that you can get general ethics credits as well as, general credits as well as ethics credits for from the Florida Bar. Okay, with that said, let's get into today's discussion topics. When we're talking about trustees behaving badly and what you need to know, some of the discussions that we're going to speak about after an introduction is, why are you serving as trustee? And have you really read the trust document? We're going to talk about the role of a trust lawyer and the rights of information, what we call relevant information, and the duties to account and to inform a beneficiary. We're going to talk about responsibility and impartiality and good faith. Those are very important factors if you're serving as trustee of a trust. And then we're going to talk about why trustees shouldn't be treating trust property as their own. We're going to talk about prudent investing and delegation of investment authority to an investment agent. And then we're going to conclude after discussing a few topics. And so what prompted this webinar on Florida trusts and family trusts? Well, having been in the trust business for over 20 years, I actually started my career on Bankers Row in Palm Beach, working for some of the country's most prestigious trust companies. I opened my own law practice some time ago, restricted to trust and estates. And I don't draft or write wills and trusts. We litigate them. We're involved in the administration and litigation or dispute resolution of wills, trusts, estates, inheritances, and now more so, now more than ever, guardianship matters. And we get into a lot of related litigation, homestead, real estate, inheritance litigation. And so I wrote this book called P.L.L.C's Trustees Guide, 10 Steps to Family Trustee Excellence. The book is free of charge, and you can get a free copy if you'd like by emailing Amanda at phflorida.com. If you email Amanda at phflorida, that's P like Pinkowski, H like Hauser, Florida, the state spelled out.com, we'll send along a free copy of my book, Pinkowski's Trustees Guide, 10 Steps to Family Trustee Excellence to you. You could also call Amanda at 561-514-0900, extension 101. So why are we here today? What's our introduction about? Well, I'm going to give you 56 trillion reasons why we're here today. There's $56 trillion, according to the Boston College Center of Wealth and Philanthropy, that's being passed down through the generations now and over the next decade or two. Right, the World War II generation, the world's greatest generation, amassed a lifetime of savings, and they're transferring 56 trillion with a T to more subsequent generations, and it's the largest transfer of wealth in humankind. And so everybody seems to be lawyering up and fighting over it, right? And really, that's what our law firm does in Florida. We handle inheritance disputes. So the first thing I think you want to think about when we see trustees behaving badly is know why you're serving as a trustee, right? And that requires some focus. And my point of this first point is control freaks should not apply, right? If you like being in charge or putting someone under your thumb, being a trustee isn't for you. A trustee should be a humble position. You're a fiduciary. Which means that you have to place, indeed you agree to place, the interests of your beneficiaries above everyone else's, including your own. So you have to know why you're serving, right? And the focus is really on the trust. What does the trust say? Are you carrying out the trust terms? And are you serving the beneficiaries, right? And everything that you do as a trustee, you should be thinking about, is this being done in furtherance of the trust, the betterment of the trust, and for the benefit of the beneficiaries? Okay, the second point that I want to bring up is reading the trust document. And this may seem kind of odd, right? I mean, everybody that knows there's a trust document. That's how we create trusts. And the trust document is think of it as the bylaws or the governing instrument or the operating agreement for the trust. It tells the trustee what to do with income, what to do with principal, how to invest it. It tells us what governing law applies. It tells us how to distribute or not distribute money to or for beneficiaries. And it also tells us under what circumstances a trustee can exercise discretion to distribute or not distribute money to a trust beneficiary, right? So read the trust document, because that's your Bible. You'll consistently go back and forth to it. What does the trust say? What do the terms say? Even when you're convinced that you actually know it, you're going to realize that you need to read it or reread it again. So know what the trust document says, because that's your guidepost for telling you how to administer the trust and how to be a good trustee. Now, reading the trust document, there is one legal maxim that's important, and that's the grantor's intent or the settlor's intent. The person who creates a trust is called the grantor or the settlor, S-E-T-T-L-O-R, the person who creates the trust. And generally speaking, the settlor's intent or the grantor's intent guides the trustee and guides the trust, as long as nothing's against public policy, right? So the trustee needs to be guided by the grantor's intent or the settlor's intent as it's expressed in the trust document. So many times you'll hear appellate courts, trial judges, and certainly appellate opinions talking about, well, what was intended by the trust? What did the person who created the trust intend? Did he or she intend that you could have $50,000 a year for a new Mercedes? Or did he or she think that reasonable transportation meant a less expensive automobile every 3 to 5 years? So one thing that we're doing in today's seminar is we're going to be speaking to you in very basic general terms so that the layperson, the non-lawyer, the non-trust attorney is going to be able to understand this rather succinctly. I'm not going to throw a lot of heavy-duty legal terms out to you or certainly use legalese, and I'm not going to mention a lot of statutes or cases or things like that. You can read the probate code though, right? Florida has a probate code. We have a trust code, right? And the Florida Trust Code is in Chapter 736. So if you want to read about trustees and trustees' duties and responsibilities, go online, Florida statutes, Google Chapter 736, and you can read all about that for free. You might also read Chapter 738, which is the Principal and Income Act, but that's rather like a different language. And finally, read the probate rules, because the probate rules and the Florida Rules of Civil Procedure will kind of tell you what's going on if you're in court. So the third point we're going to talk about when we talk about trustees behaving badly is retaining trust counsel. And that's one of the things that I often recommend for trustees, right? And so even if you don't hire my firm, that's fine, that's cool. Go get yourself a good trust lawyer, right? This is many ways a specialized field. It's unique. I know lawyers who are very good lawyers, and they can't understand trusts, and they can't understand the law of trusts. So the good news is as trustee, you're entitled to hire a lawyer under Florida law and under most trust documents, and you're entitled to have the trust pay for those attorney's fees, right, as long as they're reasonable, okay? So consider getting a good, experienced trust lawyer to help you in the administration of the trust, and you'll learn shortly that you have to provide an accounting at least on an annual basis. You're going to need a lawyer and an accountant to help you with all the requirements for your annual trust accountings. Just be mindful, this is serious business, folks, right? Don't fall asleep behind the wheel because the trustee's driving. This is serious, serious stuff. And if you don't have the time or experience to administer funds or run a trust for beneficiaries, it's better to resign and move on and let somebody else do it. Now, the next topic, or the fourth topic for us, is they have a right to know, right? And so earlier on our slides, you saw this slide of a beneficiary, a rather ragged, impoverished beneficiary on his or her knees begging the trustee for money for dental and electric bills, and the trustee is spitting fire and is devil-like in their appearance and saying, no, no, no. Don't fall into that category, right? Beneficiaries not only have a right to know about what's going on in the trust, you as a trustee are required to tell them. And you should not be the type of trustee who says no, no, no every time the beneficiary asks you a question, right? Now, there are some beneficiaries who can be talkative and can be a pain. And if you don't like them, well, you should resign as trustee, but you need to respond to them. You don't necessarily need to respond to them immediately, but you've got to respond to them in a reasonable time period, right? You've got to answer their communications. You've got to provide answers to them. Why? Well, they have a right to know relevant information about the trust. And you agreed to do that when you agreed to serve as trustee. If you're not up for the task, resign and move on and do something else and get somebody else in there who will be a trustee. So as a trustee, point 5 now, you have a duty to inform and to account. And that may not make a lot of sense to people, but you actually have an affirmative duty. It's a very serious duty to provide relevant information to the trust beneficiaries. So let me give you an easy example. Let's say that you're trustee and there's some real estate in the trust, and the beneficiary calls up and says, what are you doing with that vacant land of that house? And you say, it's none of your business. I'll do whatever I want. And the beneficiary said, well, if you list it for sale, will you send me the listing agreement? And the trustee says, no, it's none of your business. Stop bothering me. Let me do what I want. That's not a good trustee, right? You have a duty and an obligation to provide relevant information to the trust beneficiary. And if you do have real estate, like a vacant piece of land or a residence, and you're going to sell it, You do owe the beneficiary some relevant information. You should tell them whether you know what your plans are, whether you're going to sell it or retain it. You should give them a copy of the appraisal if they ask for it. Hell, you should give them a copy of the appraisal even if they don't ask for it. You should also give them a copy of the listing agreement, and you damn sure better give them a copy of the HUD-1 or any closing documents when the property sells. Why? Because you have a duty to provide your beneficiaries with relevant information, right? And this is the case in most states, not just Florida trust law, but in many states, a trustee has an affirmative duty to provide relevant information to the trust beneficiaries. And in our little example of real estate, vacant land or a residence, this includes basic things like, what do you think the property's worth? Give them an appraisal, right? Show them the listing agreement so they know who the broker is and what the broker's charging. Show them what all the closing expenses were and the attorney's fees and the title insurance or anything else. That's all decent, relevant information that beneficiaries have a right to know. Now, there's a lot of responsibility that goes with the task of being a trustee, and that includes the duties of impartiality and good faith. What does that mean? Well, in the Florida Trust Code, it's actually spelled out right there in a Florida statute that says you owe your trust beneficiaries a duty of good faith and impartiality. You also owe them a duty of loyalty. That's in Chapter 736.0802. You have to be impartial to the beneficiary, you have to extend good faith to the beneficiary, and you owe them a duty of loyalty. What does that stuff mean? Well, generally what it means is that you can't treat one beneficiary necessarily better or more advantageous than another. You have to treat them both equitably or fairly based on the governing law and the trust document. Okay, you can't discriminate. You have to be fair and equitable with them. Notice equitable doesn't always mean equal. Okay, you don't necessarily, and you shouldn't necessarily, treat every beneficiary equal because they might have different needs or wants, and the trust document may call for equal or unequal payments or distributions or not making distributions. You've got to be impartial. You can't favor. Follow the trust, follow the law, administer the trust in good faith, right? You have an obligation to do it with their interest in mind, objectively. That's important. And you have a duty of loyalty. You owe loyalty to them. Don't place your interests above theirs. Place their interest above yours. You work for them. They don't work for you. The seventh point, what's mine is not yours. I can't tell you how many trustees treat trust property as their own. That is a cardinal sin in the world of trust. Ask any Florida trust litigation lawyer, any trial lawyer who's handled trust lawsuits, and they'll tell you one of the recurring problems is trustees who use trust funds for their personal expenses. You can't do that. You have to segregate trust funds, keep them separate from your own. You have to have the name of the trust on those assets. You have to have them clearly identified, and you can't use trust funds for your own personal individual expenses. It's not an ATM, it's not your checking account, it's not a checkbook. You can receive reasonable compensation. You can hire experts and attorneys and accountants. You can pay them with trust funds, but you can't use it for your own personal money, okay? And just remember, like a judge's order, like a statute or a law, the terms in the trust are your governing rules, and they're not a suggestion. So make sure you read the trust and you understand it before you head into court unnecessarily. Point 8, the prudent investor. What's your plan? I got to tell you that a lot of trustees get into trouble because they don't have an investment strategy or a plan. And you really need one when you're managing trust funds or any funds for the benefit of somebody else. Right? You've got to do that. You need some type of a strategy. In Florida, Chapter 518.11 is called the Prudent Investor Rule, and that's our guidepost for investing fiduciary funds. Trustees, executives, personal representatives get a lot of guidance from Florida's Prudent Investor Rule when they determine what they're going to invest the trust funds in, whether they're going to invest in real estate, stocks, bonds, cash, equities, or whether they're going to sell all that stuff and go to cash, or whether they're going to keep cash or invest the cash, and invest it in what? whether they're going to invest for long-term growth and capital appreciation or the production of short-term income. These are all factors that you need to consider, and the law does not expect you to be perfect. The prudent investor rule in Florida does not expect perfection, but ineptness or inattention will not be tolerated. You need a plan. You have to consider the factors. And if you don't have a plan, that's where you get into trouble. One point on that before we move on. A recurring error committed by Florida trustees is they take over a portfolio, they take over a trust, and they don't examine the assets closely enough. Or they say, well, the prior trustee had this invested in stocks or bonds or cash or this or that, and I assumed everybody was fine with that. Wrong statement, bad statement, terrible answer. Every trustee, whether you're starting and on a regular basis, you need to understand what assets are in your trust, whether they make sense or not, whether they're part of your investment strategy or not. You have to evaluate that and come to your own conclusions. You must prudently analyze and accept or reject risks. You don't speculate. If you don't like investing, consider delegating to an investment agent, right? That's a wonderful and easy thing to do. There's actually a Florida law that lets you delegate, and your trust lawyer will know how to delegate investment functions to an investment agent. And if you actually delegate that properly, you, the trustee, can be off the legal hook if investments don't work out. So anytime there's an individual serving as a trustee of a Florida trust, I often advise them to delegate under the Florida statute or the Florida Trust Code and let an investment agent manage all the trust funds. Now, there are some holes to jump through, hoops to jump through, so you get the protection of that, and there's certain ways to do it proper, and there's ways to do it improperly, and you really should know the difference, and you should have a trust lawyer on hand who can assist you with investing trust funds. Ready, aim, fire. Our last point here that we're trying to make is that there's a lot of things that are going on in the trust world. There's investments, there's understanding the trust document, there's all this trust law that you have to comply with, and it changes. I mean, right now the Florida legislature is in session. Every springtime, we seem to get new changes to the Florida probate code or the Florida trust code. So we were constantly getting changes to Florida trust law, and you have to be on the cutting edge, right? So ready, aim, fire, be ready and set and be ready to go. It's not an easy job. It does take professionals. You should be talking to your beneficiaries. You should be accounting on an annual basis. You should be communicating regularly, right? And you should understand what the trust says. Now, I will tell you this, a lot of people, a lot of beneficiaries of trusts don't like the fact that their inheritance is in a trust. They would rather have the cash outright. But mom or dad, whoever created that trust, that settlor of the trust or the grantor of the Florida trust, made a decision not to give you the money outright, right? They made a decision to leave it in trust and have this person, the trustee, manage the money for you. So a lot of people find this frustration with trust. They don't like it. They don't want trusts. Now, dealing with that in your trustee are important factors, but let me leave you with a couple of points. One is that just because you don't like your trustee or you don't like the trust doesn't mean that you can get rid of the trust or get rid of the trustee, right? To remove a trustee, there's a very specific law in the Florida Trust Code on this, right? And you can only remove a trustee under certain limited circumstances, and you need to know what those are, and you have to prove it at a trial. Mere disagreement or disharmony between a trust beneficiary and a trustee generally never serves as a reason to get rid of a trustee. You need some type of serious breach of trust, some malfeasance, misappropriation of funds, some breach or break of the trustee's duty to remove that trustee. Now, finally, if a trust has existed over a number of years, or there's a change in circumstances that the person who created the trust didn't anticipate, or there's something that could be done that would benefit all the beneficiaries. You may be able to go in and change the trust. You might be able to modify it under Florida trust law. You can actually change the terms of a Florida trust under certain circumstances when it's in the best interest of the beneficiaries, or if things as circumstances had changed that weren't intended by the settlor, the person who created the trust. So you can modify it, and whether you have to go to trust court, probate court or not in Florida depends on whether everybody, including the trustee, agrees to modify the matter or not. Finally, if there was a mistake in the trust, you have the ability to reform it or correct that mistake, and you can go to court and reform that trust, or you can reform it or change the terms of that trust to correct the mistake. Different than a modification. A reformation corrects mistakes. If there's no mistakes, you're not going to get reformation. A modification is you're trying to change it. Last note on that. Sometimes, not all the time, sometimes courts will permit you to get your trust inheritance a lot earlier when you bust up the trust. If the trust isn't working, if everybody's fighting, there are some things that you can do. One, you can sever the trust into multiple shares so that each share is for a different beneficiary or a different segment of the family, right? And you can administer them almost as separate trusts. But sometimes courts will let you kind of blow up a trust or void a trust where you break it apart and the money is split between the beneficiaries, and the trustee resigns or goes away. The trust is dissolved. Every trust beneficiary gets a share, and there is no more trust. And there's advantages and disadvantages to that. Most trial judges are very familiar with that, and they weigh those issues very, very carefully. So my name is John Pinkowski. I hope you've enjoyed this talk about trustees behaving badly, some of the things you need to know if you're administering the trust, or you're a trust beneficiary, or you're a trustee. If you have any questions about Florida trust or estate law, guardianship law, any real estate or business litigation, family wealth litigation, feel free to give me a call or my law partner, Robert Hauser. The numbers are on the screen, 561-514-0900, extension 101, or you can email Amanda at phflorida.com. My name is John Pinkowski. This webinar has been brought to you by Pinkowski Hauser. We're a litigation law firm in downtown West Palm Beach, Florida. Our practice is restricted to litigation and dispute resolution and appeals involving wills, trusts, and estates and related areas. It'd be a pleasure to assist you if we don't have any conflicts and can speak with you. And then we invite you to give us a call or email us if we may ever be of assistance. In conclusion, I encourage you to check back on our website, phflorida.com, for future webinars that we'll be offering the general public, as well as CLEs for Florida licensed attorneys. My name is John Pinkowski. Thank you for listening.